Hi everyone, my name is Jack. I'm with Saga.
I'm Daniel Janks. I'm also with Saga.
And we want to talk to you about what's going on right now with the Department of Employment and Labour and the performance sector. But how does that even fit together, Dan? Why are actors talking about employment and labour when we know we're not employees?
So for the first time, the Department of Employment and Labour are starting to turn their attention to the independent contractor or freelancer sector of the labour force.
Actors are freelancers. Actors are independent contractors. Actors are not protected under the Labour Relations Act or any of the other labour laws that we mentioned.
So we fall completely outside of all of those legal systems which protect workers under South African law.
And if you want to talk about where exploitation starts in the freelance performance industry, film, television, live theatre and events, it is precisely there. So that's a good starting point, I think, to try and understand and unpack where unfair exploitation and the injustice of our industry starts. It is the fact that we are not protected under labour law. Now, we really need some kind of protection, but at the same time, we can't afford to give up our status as freelancers. Let's just unpack that a little bit.
So there are many reasons why we want to remain freelancers. One of the big ones, which everybody always mentions, is our tax status. As independent contractors, we have the right to claim back expenses that we incur in pursuing our careers. So petrol, going to and from auditions, maintenance of your car to go to and from auditions and onto set and off set and to theatres. Anything that you buy to further your pursuits as an actor. You buy a camera so you can do self-tape auditions. You buy a computer so that you can edit those self-tape auditions. You buy a nice suit so that you have something to audition in for formal roles like that. Any expense that you incur in pursuing your career, you can claim back at the end of the year and end of the tax year when you are submitting your tax return.
The magical code 3616. That's the tax code that SARS knows identifies you as an independent contractor, and it basically allows you to claim all those expenses back if they were incurred in pursuit of your income. Now that applies to freelancers, and we as actors do not want to give that up.
Absolutely not. Also, as independent contractors, we have the right to contract. So when we get a job, we can sit down with the person who's giving us that job and we can draft a contract. And we can, theoretically, put whatever terms in that contract we think are fair for that job. Unfortunately, the right to contract doesn't really protect us because of the massive imbalance in power that exists in our industry. Anyone who sat down with a producer, a broadcaster, and said, I think that these are unfair clauses in the contract, and they say, take it or leave it, do we really have the power to contract?
So that's where the exploitation starts. So on the one hand, we want to protect our status as freelancers, as independent contractors. We want to continue to contract our work to as many different producers as we can. We want to continue to claim back our expenses from SARS. And at the same time, we must also have some kind of protection, because if you have to look around the world and the performance, film, television, theatre production industry around the world, South Africa, unfortunately, remains far behind the rest of the pack. That's because globally, you have what they call collective bargaining rights. Actors are able to belong to unions. Actors are able to sit across the table from broadcasters, producers, and sit alongside the directors and the makeup artists, and everyone is fairly represented in a transparent process that allows people to come up with the terms and conditions of contracting as well as what rates should be. And that's a very fair process. South Africa is nowhere near that. And we are looking to try and build some kind of a structure where freelance actors like us will be able to maintain our status as freelancers, but at the same time have some kind of protection which already exists in the world of labour law.
A few months ago, before COVID-19, before the lockdown, the Department of Employment and Labour, in reaction to various things that happened in the industry, they published in the Government Gazette their intention to deem everybody working in the film and television industry as employees for certain sections of the Labour Relations Act. This is very, very important. A lot of people had a knee-jerk reaction and said, we don't want to be employees, we want to keep our status as freelancers, as independent contractors, because they didn't understand what the Department of Employment and Labour had actually done. What they had done is they had said, for certain sections of the Labour Relations Act, we want to deem workers in this industry as employees. And they listed those sections very specifically, things that had to do with leave, maternity leave, sick leave, what else? Access to the CCMA, did they include that?
Yeah, that's the conflict resolution part, a hugely important part of that as well. And of course there are maternity benefits and things that don't apply to freelancers that needed to be factored in to a discussion.
And this was a problem because the department didn't really understand our industry. So they made this sort of one-size-fits-all blanket attempt to try and fix some of the problems that they had identified. But because this is a democratic process, they made this, they published this intention, and then they opened it up to submissions from the public. Do you think this is a good idea? Do you think this is a bad idea? Are you in favor? Are you not in favor? And how do you think this will work? What do you think will work and won't work? And so different people and organizations in the industry had the opportunity to make submissions to the department about what they thought about this proposition.
So of course, SAGA, among its associate organizations, were very excited to engage in this process with the Department of Employment and Labour. And ever since November 2019, we have been making our submissions. Fortunately, we have a very strong labour partner in UASA and with FEDUSA as well, and we were able to make some very strong submissions just to give the department an idea of what it is that we need and what it is we already have that we are trying to protect. And since then, the department has called for a number of engagements, and in February 2020, just before the lockdown, Dan, you remember, there were two important engagements at NEDLAC.
Because let's be honest, their initial concept of this deeming for certain provisions of the Act wasn't really applicable in many senses. If you're going to a voiceover for 20 minutes, how do you get maternity leave? You can't. So part of our initial submission is what we thought did and didn't work about their proposal, and how we thought it could be made to work if that's what they decided to do, and what SAGA believed would be a more appropriate response. So we went to NEDLAC and we sat down and discussed these things.
And we made our proposals. So what is SAGA's proposal? SAGA has made it very clear that we are one organization amongst many other organizations in our film, television and live theatre sector. And we want to be able to communicate with them in order to arrive at certain basic minimum terms and conditions and rates in our contracts. Very importantly, we told the department, we do not want to lose our independent contractor status. Our relationship with SARS as freelancers is very important. We are not going to give that up, but we are looking for certain protection under existing labor law. So we have the opportunity then to break down what are those parts of labor law that we would like to have. And very importantly, our proposal essentially said we like the fact that we can have industry self-regulation. Self-regulation is important because we want to decide amongst ourselves how our industry should be regulated. And with that, whatever comes out of our decision-making process, which is going to be very transparent and interactive and engaging, it also must have force in law. And this is important because if the agreement that you come up with doesn't have any force in law, none of it is enforceable.
Which is what we have now.
Yep.
SAGA can sit down with broadcasters, with theatres, with producers' organizations. We can come up with a standardized contract which has terms and conditions that both sides of the table think are fair enough to be moving forward with. And we can have that contract, they can sign off on that contract, but anybody can choose to use that contract or not. There is no way to force, under law, any producer, theatre, broadcaster to actually use the contract, no matter who has agreed that it is the proper contract to use.
I think the words, now the big words that need to come out here, were the words that are being kicked around by the department, and they understood what we had to say. They looked at our proposal, and there were many proposals from different organizations, and that's all part of the process that the department has engaged in. it is a very fair and transparent process, and they said, send us your submissions of how it's going to work. And based on that, the department then compiled all the submissions and then produced a summary report. And with that summary, it became clear.
Before we get into the report, maybe we should just summarize for you what SAGA's position is, and it's 2 words. It's called collective bargaining. So to summarize it in very simplistic terms, SAGA and a lot of our partners sat down with the Department of Employment and Labour and said, if you're going to make changes to the law, if you're going to deem us as employees, all we really want is for you to deem us as employees to empower us to collectively bargain, so that we can sit down with all parties in the industry and self-regulate, and that those regulations, those agreements that we come to, are enforceable by law.
Exactly. So what we have now is, and perhaps the department agrees that maybe collective bargaining is still some way off. But for now, we do have, as the department mentioned, we have sufficient consensus to proceed. And what does this mean? It means that there is a large enough group of industry organizations that have all agreed that we need self-regulation, that's important. And
enforceable by law.
Enforceable by law, yes. And we'll get to those mechanisms, because the department describes it as informal self-regulation with a sectoral determination.
Let's unpack some of those things.
Yeah, it's quite big. Let me just mention that again. It's informal self-regulation with a sectoral determination.
So formal self-regulation would be a formal collective bargaining council. The law doesn't allow us to do that yet. So they've said, let's do an informal version of self-regulation. Well, that's what we have now.
Yep.
Completely informal. We can self-regulate. I can say I want this, and the producer says, no, I want that, and we can make an agreement or not. But because it's not enforceable by law, it's completely informal and doesn't really help us. So then they said, informal self-regulation with sectoral determinations. What is a sectoral determination, Jack?
Let's take an example. If we're going to say the TV production subsector. Remember, we've got a far bigger sector, and that includes film, television, theatre, and all of that. But within that, there's a smaller subsector, and that would be TV production, just TV production. Who are we talking to? We're talking to SAGA because we represent actors. We're talking to independent producers. We're talking to the broadcasters themselves. We are talking to agent representatives. So that kind of would be the constituents involved in that subsector, talking just about TV.
And crew. Let's not forget about crew. Crew is
course,
very, very important.
Of course. And when all of them sit together, through that process of discussion and negotiation, they would come up with a kind of an agreement of what that subsector should be agreeing on as basic minimum conditions as far as working regulations go and as far as rates go. So out of that little subsector, they've produced a document, a proposed document. That document would then go to the minister, and he would look at this and say, well, if you are sure that this is properly consulted on, and if you're sure that all the terms and conditions that you have in this document suit everyone to the best possible negotiated agreement, then yes, I'm prepared to make this a sectoral determination which will be issued in a government gazette. And that is what makes it enforceable by law. The sectoral determination issued by the minister as a result of a consulted bargaining effort that negotiates everybody's interests in one forum. So informal self-regulation with sectoral determination, that's what SAGA is pursuing. And this is very much an historic process, Dan. If you think about it, if our industry, if our sector has never been regulated before, how would you like it to be regulated? And this is why being part of an organization is such an important aspect. Your voice has got to be heard. Or the alternative is your voice is not heard, and the sector continues to evolve and progress without you. But that's not how democracy works. We have the opportunity now to say we belong to an organization, or my voice is being heard in a certain way. I have mandated that organization to speak with my voice. And I am happy that the message that they are taking forward accurately reflects our concerns, our grievances, our interests, and our values in this industry. So it's very much up to us how we want our industry to be regulated and how it reflects our interests. So I encourage all actors, if you are not yet a member of SAGA, this is a great opportunity. This is how you become part of the creation of an industry that reflects you, what your interests are.
This is the first time in history where we are now given the opportunity to be protected by law. And we need you to be SAGA members so that we have the ability to represent you in this process.
And we hope to bring you further updates as this process continues to unfold. So thanks for joining us, everyone. We're very glad that we were able to bring this update, and maybe there'll be more to come.